So today I want to talk about data protection impact assessment best practices. You have a copy of the slides in the folder, of course. These are the sorts of things that I want to talk about: definitions, the key elements in Article 33, the need for more detailed guidelines, PIA methodologies, good practices, issues, recommendations, and references. So there is, in my view, a distinction between a privacy impact assessment and a data protection impact assessment. The ISO, the International Organization for Standardization, is working on a standard of privacy impact assessment now. It's quite advanced, and the definition that they use is the following that you see here: a tool for assessing the potential impacts on privacy of a process or other initiative which processes PII, and this is the important bit, and in consultation with stakeholders for taking actions as necessary in order to treat privacy risks. Also, I think it's important to realize that a privacy impact assessment is not just about compliance, it's about identifying risks and solving those risks. So this is the definition of a DPIA from Article 33 of the GDPR, where a type of processing using new technologies and taking into account the nature, scope, context, and purposes of the processing is likely to result in a high risk for the rights and freedoms of individuals. The controller shall, prior to the processing, carry out an assessment of the impact, blah, blah, blah. So there's some slight differences there. One is that the ISO definition refers to consulting stakeholders, whereas the GDPR does not, or at least not in the context of the definition. So I'm not going to go through, I'm not going to repeat what's in Article 33, but it does specify where a DPIA is required, and you can see the various points here. And I think a very interesting point is that, and it's a difference between the current version of Article 33 and the version that appeared in 2012, the Commission's version of the GDPR. The supervisory authority shall establish and make public a list of processing operations subject to a DPIA. And then they say in Article 33 what the DPIA shall contain, and I'm not going to read all of those points. It's somewhat similar to the wording that was used in the original version of Article 33. Now, it does talk about consulting stakeholders, or at least data subjects, and there is a difference between stakeholders and data subjects. But it does refer to consulting stakeholders. And then also it says, and this is retained from Clause 6 and 7 from the original Article 33, the Commission shall be empowered to further specify the likely risks and requirements for the DPIA, including scalability, verification, and auditability. The Commission shall consider specific measures for SMEs, and the Commission may specify standards and procedures for carrying out, verifying, and auditing the DPIA. Now, these two clauses came from the original Article 33 in the January 2012 version, and they've been retained here. And I think they're quite important clauses, at least as far as the Commission is concerned. And I think it's something that stakeholders need to take into account, i.e. that the Commission, if it so decides, can specify further specify the requirements for carrying out a DPIA and having those audited. So let me just go back to this point. So you know, if the Commission is able to carry out or arrange for an audit to be carried out, if they can specify the kinds of requirements for conducting a DPIA, where are they going to get it? I mean, the Article 33 is 2 pages long, and there's not a lot of detail as far as guidelines are concerned. So I think it's inevitable between now and the time that the GDPR comes into force that the Commission is going to have to start thinking about providing more detailed guidance to controllers about how to conduct a DPIA. Now, there's lots of sources it can go to, and I list some of the PIA guidance documents that exist right now. There's the ISO PIA guidelines, which, as I mentioned a minute ago, are almost finished. The French regulator CNIL has produced a PIA methodology. The Information Commissioner's Office in the UK has produced this PIA Code of Practice, and so forth. The one that's 6 bullets down, the OAIC, that's the Office of the Australian Information Commissioner, Guide to Undertaking PIAs. If you want a good guidance document, I would recommend from this list that Australian guidance document in particular. I think we need to ask ourselves what are some good practices of controllers. And having looked at many PIA guidance documents over the last few years, and indeed produced, I think, still the one and only book on privacy impact assessment, I'm just identifying a few of the key points from those various methodologies that I've looked at that I think are reflective of good practice. So the first point, I think, is an important one, that the DPIA should be carried out when there's still an opportunity to influence the outcome of the project. A DPIA can still be carried out even after the project has been deployed, after the technology or the process or whatever initiative involves the processing of personal data, but it's not nearly as effective in terms of being able to influence the outcome, making some changes when there's still an opportunity to, I would say, save costs involved in conducting or carrying out a new technology or a new process. Retrofitting a new technology or a new service for privacy safeguards is a lot more expensive. Over the last 3 or 4 years, I've changed my views a little bit with regard to who should carry out the DPIA. When I originally started thinking a lot about and writing a lot about data protection impact assessments or privacy impact assessments, I felt that generally it was important for organizations to develop an expertise for carrying out privacy impact assessments. So generally, I thought they should use their own people to carry out those privacy impact assessments, rather than contracting with an outside assessor. Having conducted some privacy impact assessments for different clients, I've come to change my point of view on that, and that is that I think that having a third party carry out the data protection impact assessment or PIA is actually a way of giving more credibility to the result. And indeed, some of the clients that we've had have contracted with us, I think, for exactly that reason. They think that having a third party, an independent assessor, gives the DPIA or the PIA more credibility. I mentioned this point about consulting stakeholders. I think that's very important in carrying out a credible privacy impact assessment. It doesn't have to, you don't have to consult with every conceivable stakeholder, but I think it is important to consult with different stakeholders for some different reasons. One is that it gives the result, the privacy impact assessment report or DPIA report, more credibility. Secondly, I think it's a way of identifying risks that the organization may not have identified early on. So I think there is value in consulting stakeholders. I think the stakeholders themselves will feel better towards an organization that consults them rather than an organization that just takes some arbitrary decisions that impact data subjects. I think it's useful for organizations to consult the DPA depending on the scale or the context or the magnitude of the risks that are involved. Certainly many organizations have consulted with the ICO in the UK, and I know it's the case in some other countries as well. I don't think it's necessary to do so in every single instance whenever you're going to carry out a DPIA. It really depends on what the organization thinks, how serious they think the risks are. The other stuff, mapping the information flows, I think that's that's pretty much standard across most PIA methodologies. Identifying the risks and benefits, I think that's important too, and especially the benefits. The problem with assessors who are carrying out a DPIA is that they are generally criticizing an organization's data protection practices unless the organization is squeaky clean. And I think that's a little bit unfortunate. So I think the DPIA should also identify where there are. They should also identify the benefits of a particular technology or new service that the organization wants to introduce. So DPIA should not be just an exercise in criticism. I think it's highly desirable to publish the DPIA report. Many organizations are very reluctant to do so because of commercially sensitive information, or maybe in the case of a government agency because there's some security implications. And so I think those are understandable, but I think it's very interesting to note that the U.S. government, including the FBI and the Department of Homeland Security and so forth, they do publish their PIA reports, and they publish them on their website. You can go to the FBI website and you can find a long list of the PIAs that they've conducted. In the case of Canada, for example, they don't publish the full PIA report, but they do publish a summary. And so you can, and again, there's a website or a web page at the government agencies where you can find a list of all these different PIAs. And I think there's value in doing that. Even from the organization's point of view, there's value in publishing the PIA or DPIA reports. I mean, it's a way of showing to stakeholders, showing to customers that the organization takes their data protection seriously. So, I mean, I think there's some good PR value there. But I think also it's a way of organizational learning. Different people, especially in large organizations, they do not have to reinvent the wheel every single time. So if there's a kind of library published online, it's a way of organizational learning. And I mentioned this issue of third-party review or audit. Again, it's a question of the scale of the risks involved in a new service or a new technology or any initiative involving the processing of personal data. But if the organization wants to be credible with its PIA, subjecting the PIA to a third-party audit or review is a very useful way of doing that. And the registry of DPIAs, I've mentioned that already. So in the next couple of slides, I'm just giving you some examples here of PIA reports. The first one is from the London Metropolitan Police. They've published their report. The next one is from the UK Border Agency. Again, they've published that report. Sometimes organizations do want to publish a privacy impact assessment. They don't do it reluctantly, but they want to show to the public, to other stakeholders, that they are taking their data, protection of their data seriously. So they get some value from that. Next one is from the Irish government. They published a PIA on their national postcodes project, and some more here from Australia, from Canada, and from DHS in the United States. Now, I just want to go back a little bit here. So just look at the number of pages involved. The first one with the Metropolitan Police, 43 pages long. They conducted that PIA by themselves. They didn't bring in an outside assessor. Ditto for the next one. It was 38 pages long. They conducted it internally. The Irish PIA, somewhat longer, 74 pages, and that was conducted by a third party, GemServe, a consultant. So I think that was a useful thing for them to do. In the case of Australia, that was also conducted by an outside assessor, a third-party organization, 47 pages long. The summary from Revenue Canada was just 6 pages long. Most of the summaries from Canada are about that long. They're reasonably detailed, but they don't go into the full assessment. But you get a sense of what the PIA report was about. Sometimes the summaries have been criticized because they're just too brief. They don't really tell you anything, and others are better. The DHS published a PIA that's only 8 pages long. I think that's quite typical of a lot of the American PIA reports. They're relatively short. I've seen some PIA reports from the U.S. government that are just 1.5 pages or 2 pages long. I don't think that's a credible PIA. So some PIA benchmarks. Was the report or the summary made public? Does the PIA report say who prepared it? Now, in the case of the two UK government, the Metropolitan Police report and the Border Agency report, they don't say who prepared it. There's no contact details, whereas the US government agencies, they always have the contact details of whoever prepared the PIA, not only who prepared it, but who reviewed. When was the PIA actually prepared? Were stakeholders consulted? Does the PIA report say which stakeholders were consulted? Did they seek guidance from the Data Protection Authority? How long is the report? Does the report explain the information flows? Does the PIA report identify the privacy risks, the solutions, the benefits? Does it say when it will be updated? I think these are all quite essential points for most privacy impact assessments, and I hope if the Commission publishes some guidance, these are the kinds of things that they will take into account in producing their guidance. So it's not just good practice by the controller we need to think about, but I think also good practice by the DPA. I think it is useful, as many data protection authorities have done, is to produce a guidance document. Some guidance documents are relatively short, and some of them are somewhat longer. For example, the ICO, the new version, the Code of Practice on PIA produced by the ICO a year or so ago, it's quite brief compared to the second version that they produced several years ago. It's much more detailed in terms of how the privacy impact assessment should be carried out. Of course, I think data protection authorities across Europe, if they do produce guidance, it now should be based on Article 33. I think the data protection authorities should respond to queries or draft PIA reports if an organization comes to the data protection authority and says, is this a reasonable privacy impact assessment? Should I improve it in some way, and so forth? I think the data protection authority should respond to those kinds of queries. I think it's impossible for a data protection authority to check every single privacy impact assessment that comes their way, but I think they can do some spot checks. They don't have to look at every single one, but maybe they could look at 3% or 5% of the DPIA reports. I think it's useful for the data protection authority to produce a register of publicly available DPIA reports. Again, it's a question of avoiding the need to reinvent the wheel every single time somebody carries out a data protection impact assessment. I think publishing, especially for the Data Protection Authority, to publish a list of good DPIA reports is a way of raising the game, producing higher quality data protection impact assessment reports over time. Already there's several data protection impact assessment guidances produced by the various DPAs within Europe. So, clearly I think there's a need for harmonization, and maybe the Commission, as it starts to produce some guidance with regard to how you can implement Article 33, maybe that will be the mechanism to do so. I think it's very important for there to be a good way of assessing privacy risks. From the various reports that I've looked at, the various guidance documents that I've looked at, I would say one of the weak points is, how do you assess privacy risks? And there's some different ways of doing so. I think the ISO 27005 standard is a good way of doing it. The CNIL methodology is quite similar, or even based on that 27005. But they're quite similar, those two. But there's a definite deficiency as far as how you assess privacy risks. So some questions and issues. I think one of the difficulties that an assessor has, whether the assessor is from within the organization or is a independent third party, is the assessor is in the invidious position of producing a realistic, unbiased report by the very organization that pays him. Whether the assessor is an employee or whether the assessor is an independent third party, he or she is still in that invidious position of producing something for the organization that's paying him. When will the standard or guidelines apply for DPIA in Europe? Who should conduct the DPIA? I've mentioned this already. Who will give the DPIA the most credibility? Will organizations need to show either their regulator or their clients that they have conducted an adequate DPIA? What level of detail, how much effort should be vested in the conduct of a DPIA? As I mentioned, some PIA reports in the United States are only a couple of pages long, and others, I've seen some others that are 120 pages long or 150 pages long. So I think it's important to have produce a PIA report that comes across as being reasonably thoroughly carried out, rather than something that's just checking some tick boxes. And the last point here is how should those privacy risks be assessed? Is a data protection impact assessment enough? I would say that DPIA is good for identifying and nominally it's good for identifying and resolving data protection risks, but it's not so focused on benefits. So I think that's an issue. The difference between a data protection and impact assessment and a privacy impact assessment, in my view, is a real one. A privacy impact assessment, I think data protection is just part of privacy, and so I think the Commission has made a mistake in framing a data protection impact assessment in the context of Article 33. Everywhere else in the world, they use the term PIA, privacy impact assessment, and the Commission has coined this term data protection impact assessment. And my view that a data protection impact assessment is a kind of narrower approach to privacy, and I think it doesn't nominally it doesn't take into account the impacts on other types of privacy. third point I think is important. Many new technologies raise ethical issues, and I don't think a DPIA or even a PIA is sufficiently robust to address a variety of ethical issues that are arising, especially with new technologies. I would argue that we need to look beyond just a data protection impact assessment. We should be looking at something like an integrated privacy and ethical impact assessment. And here are a list of the sorts of ethical issues that may not necessarily be raised in a data protection impact assessment report. Some of them will be, but not all of them. Recommendations. So I think the Commission should prepare some guidelines as soon as possible for how Article 33 should be implemented. I mean, people know that the GDPR is on its way, and I think it's not too early to start, for the Commission to start producing some more detailed guidelines on how to conduct a data protection impact assessment. As I just mentioned, I think the Commission should consider the possibility of an integrated DPIA and ethical impact assessment. The Commission should consider what it will do if a company does conduct a DPIA, but rather what it will do if a company should conduct a DPIA but doesn't. So I think there's some enforcement issues that need to be addressed. I certainly think that the Commission, if it's serious about Article 33, they should start selling the benefits of conducting a data protection impact assessment. And then also, data protection impact assessment, I think, should be seen as an element of data protection by design, which is Article 23, and the privacy seal or certification framework, which is Article 39. So the next three slides are some references. I won't go through all of these, of course, but if you're interested, then have a look at the slides that are in your folder, and there's 3 pages of references here, and I couldn't help but try to sell some of the stuff that I've produced myself on privacy impact assessment. And finally, some questions, and I guess Rosemary and I will take questions together. Thank you.